Hello everyone, I'm Shefali Sharma, a final year law student. Today I would be discussing about the new IT rules, that is the Information Technology Intermediary Guidelines and the Digital Media Ethics Code Rules of 2021. Before moving on to the guidelines and other related issues, I would like to share some important facts with you all. Do you know India has a huge digital population of about 624 million active users by February 2021? According to the researchers and cyber security ventures, it has been discovered that a cyber attack incident will occur at every 11th second in the year 2021, which is twice the rate which was prevalent in the year 2019. Also, more than 4,000 malicious COVID-related sites were discovered during the first wave of lockdown. With the increase in digitalization, social media users and cashless economy policy, even the cyber criminals are adopting more serious and more menacing techniques in order to commit the various cyber crimes and in order to hide their original identity. The central government of India is empowered to make rules related to information technology under Section 87 of the Information Technology Act. Further, the Ministry of Electronics and Information Technology has notified the new IT rules for the social media intermediaries, for the OTT platform, that is over-the-top platforms, and for the digital news. Today, we would exclusively be dealing with the social media intermediaries. So, the social media intermediaries are Facebook, Instagram, Twitter, etc. And the social media intermediaries are further classified into two groups on the basis of number of users. That is significant social media intermediaries, which is consist when there are more than 50 lakhs registered users. It is significant social media intermediaries, and the other is social media intermediaries. Now, I have summarized the whole guidelines into 4 major points. First is that the social media intermediaries will have to follow the due diligence. That means they will have to take the reasonable care and caution to avoid unlawful act. In case they do not comply with the due diligence policy, they will not be provided the immunity which is mentioned under Section 79 of the IT Act. Under Section 79, there are a list of cases where the social media intermediaries are given immunity. In case they do not adhere with the due diligence policy, they will not be given the immunity. The second important guidelines issued was the appointment of the Redressal Officer under the grievance redressal mechanism. The appointment of grievance officer is made, and the officer will be duty bound to address the complaint, to note down the complaint within 24 hours of the receipt of the complaint, and to solve or to resolve the complaint within 15 days of the receipt of the complaint. The third major point is the appointment of Chief Compliance Officer, a nodal contact person, and a resident grievance officer. All these 3 officers should be the resident of India, and the compliance report would be made monthly. The report would consist of all the details of the complaint, the action taken against the complaint, and the removal of any unlawful content if there is from a social media platform. Even those details should be included in the compliance report, which has to be made monthly. The fourth and most important guidelines is to enable the identification of the first originator of the information. This is also called Traceability Clause or Traceability Laws. These are called Traceability Laws because it traces the person who has first originated the information. This clause is very important for the investigation purpose or for the whole prosecution mechanism in order to find out the real culprit who has first made or the message, or who has first circulated and originated any wrongful message or any unlawful content. The prevalent situation has become like Government of India versus the social media intermediaries. Coming back, the Government of India gave 3 months time span to the social media intermediaries to comply with the provisions of the new IT rules, which began from 25th February and ended on 25th May 2021. The social media intermediary did not comply with the provisions. Instead, they demanded for the amendment in the new IT rules. The WhatsApp even approached the Delhi High Court challenging the validity of IT rules. There were two major contention made. First was that the IT rules are against the end-to-end encryption policy. End-to-end encryption policy means that the content can only be read or modified between the sender and the receiver, and the third party would not have the access to that information. Okay. The second major contention was that the new IT rules, especially the identification of first originator rule, is against the right to privacy, which is our fundamental right. Now, whenever we talk of fundamental rights, we know it very well that our Constitution of India has guaranteed us fundamental rights, which are enumerated in Part 3rd of the Constitution. Earlier there were 7, now there are 6. But these fundamental rights are not absolute. For example, if we talk of Article 19, freedom of expression and speech, we are not allowed to speak anything and everything. We cannot exercise the freedom of expression and speech by hampering the morality of the society, or by going against the sovereignty and integrity of the nation, or by passing on defamatory statement there, or by going against the public policy or order. So there are certain restrictions with respect to each fundamental right. Exclusively talking about right to privacy, we always refer to the case of Puthuswamy versus Union of India, because it is one of the landmark case for the right to privacy. Under this case, in the year 2017, a 7-judge bench in the Apex Court unanimously held that the right to privacy is a fundamental right and it will be covered under the ambit of Article 21 of the Constitution. But it has to be noted that the court has also recognized the reasonable restrictions. It has also said that the reasonable restrictions with respect to right to privacy are permissible. Therefore, there should be a line drawn. There should be a line drawn between the laws and the technology, because as the technology needs growth, even the law is dynamic. It changes according to the changing needs of the society. A line should be struck down between the law and the technology. A balance should be made, and the unbiased regulations should be formulated and should be practiced. Thank you. That was all from my part today. Hope it was of some use and knowledge to you. I'm always open for suggestions. Please let me know if any in the comment section below. Thank you.